Hello everyone. In the last presentation on torts affecting person, the rules pertaining to liability for torts of assault and battery have been explained. In this presentation, an attempt would be made to explain the rules pertaining to the tort of false imprisonment, which is also a tort affecting person. The complete restriction of a person's freedom of movement without lawful justification or excuse amounts to the tort of false imprisonment, which affects the liberty of a person. The tort is actionable per se, that is, without proof of actual damage. The restriction need not be in a prison. It may be in the open field or in a man's own house. The wrongful continuation of an original lawful imprisonment is also actionable. Even if the plaintiff submits to the restriction, it is false imprisonment unless such submission is truly voluntary. Salmon defines the wrong of false imprisonment as the act of arresting or imprisoning any person without lawful justification or preventing him without lawful justification from exercising his right of living in the place in which he is. According to Winfield, false imprisonment is the infliction of bodily restraint, which is not expressly or impliedly authorized by law. In order to constitute the tort of false imprisonment, there should be deprivation of the liberty of a person. This usually happens when a person is arrested or detained or imprisoned, but such imprisonment need not be in a common prison or jail. Every confinement of a person is imprisonment in law. Therefore, whether it be in common prison or in a private house or on a public street, when a person is detained, it is deprivation of liberty. To unlawfully prevent a person from leaving his own house is also imprisonment. The deprivation has to be complete, that is, the restraint must be such as to limit his freedom of motion in all directions. It is no imprisonment and it is no deprivation if a person is prevented from going in one or more of several directions so long as it is open to him to go in some other direction. If the person has the means of escape but does not know it, his detention is false imprisonment unless any reasonable man in his place would have realized that he has an available outlet. Actual use of force is not necessary. A mere threat of force whereby the restraint is effected is a sufficient ground for action. In almost every case of false imprisonment, one person comes in contact with another person and thus some force is used at some stage. But the use of force is not an essential ingredient. By show of authority also, a person may effect restraint without coming in contact with another person. The imprisonment must have been caused by the defendant or his agent or his servant. The tort of false imprisonment is concerned with deprivation of liberty by an individual or by a ministerial officer of government. A theoretical question which rarely arises in practice is whether the plaintiff must be conscious of the imprisonment. After conflicting authorities, the House of Lords in Murray versus Ministry of Defense opined that this consciousness is not necessary, though with the rider that a person who is unaware that he has been falsely imprisoned and has suffered no harm can normally expect to recover nominal damages only. The basis of law as stated in Murray is that personal liberty is supremely important so that interference with it must be deterred even where there is neither consciousness nor harm. But a good deal can be said for the contrary view, for in the absence of actual damage, the wrong is essentially to the plaintiff's dignity and feelings, and in this respect, what you do not know does not hurt. The necessity for knowledge has been accepted by the American Restatement of Torts. Restraint may be either lawful or otherwise. Where it is lawful, there is no false imprisonment. But where it is unlawful, there is false imprisonment. Actions for false imprisonment have sometimes arisen when the defendant has refused to let the plaintiff out of an area which he entered voluntarily or in which his restraint was initially lawful. Where there is a legal duty by contract or otherwise to let the plaintiff out, a refusal to comply with this will be false imprisonment, despite the general rule that failure to act cannot be a trespass. Failure to release someone in the absence of such a duty is not false imprisonment. If the plaintiff has voluntarily entered the defendant's premises, subject to one or more conditions of which he is aware or must be aware, then the defendant is entitled to take active steps, including the use of physical compulsion, to restrain him from breaking those conditions. Now let us look into some of the leading cases on false imprisonment. In Bird versus Jones, part of the public footway was used to provide seats to witness a boat race, and it was separated by temporary fencing. The plaintiff, claiming the right to use that part of the footway, climbed over the fence but was stopped by the policeman, who told him that he might go back if he pleased. He refused to do so and remained there for half an hour. When stopped like this by the policeman from proceeding in a particular direction, but not stopped from going in any other direction, he maintained an action for false imprisonment. It was held by the Queen's Bench Division that there was no imprisonment at all. The court observed that the general public have a right to use the footways, but on occasions such as the one involved in this case, a partial restraint on the right of the public to use the footway was a reasonable restriction on the rights. Further, false imprisonment is constituted when a person is totally denied the freedom of movement and is confined in a prison or in any room, etc., within the circumscribing limits. Since the plaintiff was allowed to go in the other direction, it was not considered as false imprisonment. In Robinson versus Balmain New Ferry Company Limited, there was a structure built out in the sea as a stage for the passengers to board a ferry. By the regulations of the company, a penny was to be paid at the stage while entering upon the ship, and a penny again on getting out of the ship at the stage itself. A man had taken a trip by the ferry and refused to pay while getting out of the ferry. The manager of the company refused to allow him to get out of the ship. He was detained for non-payment. It was held that this was not false imprisonment. A person who accepts certain terms has to fulfill them by action. These may be expressly agreed upon or may be implied from a transaction. To all such cases, the doctrine of voluntary non-fit injuria is applicable. In Kundan Lal versus Desraj, a surety applied for cancellation of bail bond. The superintendent of police cancelled the bail bond and ordered the rearrest of the plaintiff. In accordance with these orders, the plaintiff was arrested by sub-inspector. The power to cancel the bail bond and order the rearrest could be exercised only by a magistrate under the Criminal Procedure Code. It was held that since the superintendent of police did not have such a power, his arrest and consequential rearrest of plaintiff were unlawful. Both the superintendent of police and sub-inspector were liable for false imprisonment. When arrest is made under lawful authority or under justifiable circumstances, or where an arrest is made under a warrant or without a warrant, but as provided by law, such deprivation of liberty does not amount to false imprisonment. Similarly, when the arrest is made for preservation of peace or is justified by judicial authority, or when the detention is under war emergency legislation, the deprivation of liberty will not amount to false imprisonment. The criminal law of India prescribes punishment to those who deprive a person of his freedom, while the law of tort provides remedy only when there is total deprivation of liberty. The criminal law prescribes punishment when there is total as well as partial restraint. The two situations in which a person loses his freedom are termed as wrongful restraint and wrongful confinement under the criminal law. According to section 126 of the Bharatiya Nyaya Sanhita, wrongful restraint is voluntarily obstructing any person from proceeding in a direction in which that person has a right to proceed. According to section 127 of the Sanhita, wrongful confinement is wrongfully restraining a person in such a manner as to prevent that person from proceeding beyond certain circumscribing limits. In India, as a defense, a person charged with false imprisonment may plead that there was only partial restraint and other reasonable and practical ways of escape were open to the plaintiff which he could have made use of. He may also plead that the situation created was because of an agreement between the plaintiff and the defendant, to which the principle of volunty non fit injuria will be applicable. He can plead that he did not cause the arrest of the plaintiff. He can also plead that the detention was lawful and take refuge under the Judicial Officers Protection Act 1850. If he is an executive officer, he has to prove the justifiability or legality of his action as per the powers given to him by a statute. When a private person detains the other but hands him over to the police as soon as it is reasonably possible thereafter, he can bring his case under section 40 of the Bharatiya Nagarik Suraksha Samhita and defend himself by showing that the person detained was committing a cognizable and non-bailable offense in his presence. If he proves this, the plaintiff fails, and the question whether the defendant had a reasonable or probable cause for doing so would be immaterial. Now, coming to the constitutional protection to personal liberty, the right to life and personal liberty is one of the fundamental rights enshrined under Article 21 of the Constitution of India, according to which no person shall be deprived of his life or personal liberty except according to the procedure established by law. Article 22 provides certain additional safeguards against illegal arrest and detention. Due to these constitutional safeguards, the right to personal liberty cannot be restricted or abrogated. If one is illegally arrested or detained, he has the constitutional remedy of filing a writ petition under Article 32 in the Supreme Court or under Article 226 in the High Court, whereby he can enforce the rights secured by Part 3. This is a remedy to move the court by praying for habeas corpus or any suitable writ. In Rudulsa versus State of Bihar, where the petitioner was illegally detained in jail for 14 years after the court had ordered his release, the Supreme Court ordered compensation of Rs 35,000 to be paid to him for unlawful detention and thereby linked constitutional remedy of habeas corpus with compensation and set the pace in the direction of protection of personal liberty. Remedies open to a person wrongfully detained are self-help, damages under tort law, and a writ of habeas corpus for release from wrongful detention and for award of compensation for the injury suffered due to such illegal detention under Article 32 or Article 226 of the Constitution. The wrongdoer can also be prosecuted under Section 126 or 127 of the Bharatiya Nyaya Sanhita for wrongful restraint or wrongful confinement, as the case may be. This, in brief, is about the tort of false imprisonment. Thank you.